May it please the Court, Your Honour. My name is McKane, first initials RT, and I appear on behalf of the applicant in this matter. Your Honour, I submit this application by way of Section 130 of the Evidence Act and Section 590AA of the Criminal Code, with regard to the procedures used by the Queensland Police Force to obtain my client's admissions under the Police Powers and Responsibility Act, herein referred to as the PPRA. We argue that the PPRA has been completely neglected by the police present during my client's detaining. In contravening these procedures, my client's statutory entitlements, age, and cultural background were completely disregarded. Thus, we present in the application that the breaches made under the PPRA during the detaining and interviewing of my client justify exclusion of the Crown's evidence by virtue of either the public policy or fairness discretion. Your Honour, it is firstly submitted that the admissions made by my client contradict public policy factors established in Bunnings and Cross. Specifically, that procedures undertaken by police against my client were unlawful and improper. My client was arrested at 10 a.m, thrown in the back of a police car for 3 hours, and finally charged at 7:05 p.m. that night, a staggering 9 hours and 5 minutes after being arrested. Your Honour, this clearly contravenes Section 403 of the PPRA, which allows police to detain a person for a reasonable time up to a maximum of 8 hours. Not only did the police violate this 8-hour limit, they failed to even consider the external factors regarding what a reasonable time constitutes. My client is a child of Aboriginal descent, in unfamiliar surroundings, and most likely in an unstable state of mind, considering the events of the previous night. What is reasonable in these circumstances is far less than 8 hours, as supported by Section 404(1)(e) of the PPRA, let alone 9 hours and 5 minutes. Additionally, Your Honour, being just 15 years old, my client is protected by the provisions in Section 421 of the PPRA. Part 1A of this section requires that my client be given the opportunity to speak privately with his support person, in this case his mother. On the facts, this did not occur. Yet again, another blatant failure in the police's statutory requirements towards my client. Furthermore, Your Honour, consideration should be had to Section 420 of the PPRA, given that my client identifies as a person of Aboriginal descent. Now, we concede Section 420 does not explicitly apply to children. However, we submit the Court should consider the requirements in Section 420 to inform their interpretations of Section 421. Most importantly, the requirement that legal aid be contacted when an Indigenous person is in custody without legal representation. My client explicitly stated that he did not know any lawyers, and as such, was told by the police that Aboriginal legal services would be contacted. Your Honour, this was a lie, as this never occurred. The police were aware of their duty to give my client legal aid, and yet again failed at their statutory requirement. They detained and questioned my client, an Aboriginal child, for 9 hours with no legal representation present. The misconduct by the police against my client is outright appalling and absolutely questionable in intention. The repeated transgressions made by the police against my client were a calculated disregard for the law. With this in mind, we believe the Court should be guided by the principles set in Bunning and exercise their discretion in determining the admissibility of the evidence in question. The errors made were not mere mistakes, Your Honour. They were deliberate. The PPRA was enacted to safeguard the liberty of suspects and to an even greater extent Aboriginal children. We argue this has been breached, and on the balance of factors agreed to in Bunnings, we submit that the Court should use its public policy discretion to exclude this evidence under the power granted by Section 130 of the Evidence Act. If the Court finds that the public policy discretion is not appropriate, we submit that the Court should consider the fairness discretion first established in Christie and reaffirmed in Lee. We submit that the evidence obtained against my client would be substantially more prejudicial than probative if accepted in court. Your Honour, we would like to draw your attention to the case of Swaffield, where it was decided that a breach in the defendant's legal rights during the investigation process satisfied the requirements for the courts to implement the fairness discretion. As discussed previously, the police breached my client's legal rights substantially under the PPRA. Furthermore, my client did not give evidence to the Crown's case under his own volition, as was a defining factor against the fairness discretion in Appleton. Justice Dixon stated in McDermott and the Queen that a confession cannot be voluntary if it results in duress, intimidation, or sustained insistence from the police. After the previous night's events and the unlawful detention of my client without legal representation nor privacy, it is evident that my client, a child, was under extreme duress. The police abused their power to strike fear into my client, and thus, Your Honour, his admissions cannot be deemed voluntary. As you know, Your Honour, a fair trial is the cornerstone of our judicial system. Allowing this prejudicial evidence to be admitted would likely result in the opposite. Thus, we submit that applying the fairness discretion to exclude the evidence against my client is not only justified, but necessary to ensure a fair trial. As Your Honour pleases.